Okay, I am back, and here we are for lecture 2 of topic 10. And in this, we're looking at the part 2 of abortion rights. Okay, so in the last lecture, we did a deep dive on Roe v. Wade. And in this lecture, we're going to take a look at the aftermath of Roe. And to think about what the aftermath of Roe, where we are in terms of abortion law right now, we'll take a look at the landmark case, Planned Parenthood of Southern Pennsylvania v. Casey, a 1992 case, so nearly 20 years after Roe. And then we'll look at where we are today and abortion in the Roberts Court. So let's go ahead and get started. In the last lecture, we talked about how abortion and the issue of abortion wasn't really like a politically salient or important issue in the 1970s. But following Roe, that all changes. And the response to Roe is very strong and it's very polarizing. And basically, you have two camps sort of develop in the United States as it relates to abortion policy. I know most of you are familiar with these terms, but I wanted to make sure that we were all clear on these terms. Following Roe, there's basically a development of people on opposite sides of Roe. Although keep in mind that the majority of Americans support the decision of Roe. We saw that in the last lecture. But you have pro-life factions and groups and interest groups develop, and pro-choice interest groups. Pro-life interest groups are those, as the title suggests, that want to overturn Roe, that they disagree with the ruling in Roe, and that basically they think that abortion should be illegal in the United States. On the flip side of that is the pro-choice movement. And this is a faction that is basically supporting the decision in Roe, sees the right to terminate a pregnancy as a fundamental right that women have, and they're fighting hard to not just maintain Roe, but to get rid of some of the regulations that have been deemed constitutional coming out of Casey, which we'll learn about in a moment. The development of this polarization didn't happen in a vacuum. And so the 1960s and 70s are a time period where people in the progressive left get involved in politics. You have the anti-war movement, you have the civil rights movement, and then you have the women and gay rights movement as well. And all of those take place in the 1960s and 70s. And it's really, evident that liberals and progressives are actively involved in politics and actively trying to make change. Up to the 1970s, people who were not just conservative, but that were Christian conservatives that had sort of, fundamental beliefs about traditional family, traditional roles of men and women, and fundamental beliefs regarding when life begins at conception, and other beliefs, conservative beliefs as well. Up until the 1970s, evangelical Christians, Christian conservatives sort of sat on the sidelines in politics. Their thinking was that they didn't want to get dirty by getting involved in politics. It was like dirty business. It was like the business of the earth, right? And that many evangelical Christians had their eyes set on the afterlife. That they were more concerned about their spiritual life, their internal life, their personal life, and their personal relationship with Jesus Christ, and that they were living their life according to those principles, concerned about living a godly life so that they could then ascend up into heaven and have an afterlife of paradise. And so, up until the 1970s, really the mid-70s, really even the later 70s, evangelical Christians sort of sat on the sideline. They were like, no, we're not going to get involved in the dirty business of politics. But, coming out of the 1970s, where we saw increasing liberal laws regarding abortion, contraceptives, gay rights laws, expanding the rights for gays and lesbians in the United States, there was a response to that and a rise of a group called the Christian right, the moral majority, Christian conservatives. I mean, that all starts percolating up, in the 1970s. And the thinking is that we can't sit on the sidelines anymore, because if we do, then we're going to lose God in schools, that traditional family will be destroyed, and that, really there will just be rampant immorality in the United States. And so the Christian right aligns themselves with the Republican Party in the United States. I remember in the last lecture I said that the Republican Party prior to the 1980s was supportive of women's rights. They were supportive of abortion rights. That changes when the Republican Party, for political strategic reasons, and made a lot of sense, that made them, it was like the revival of the Republican Party, aligned themselves with the Christian conservatives. And that was sort of embodied by Ronald Reagan's alignment with the Christian right, and then continues with somebody like the President George W. Bush. And so the Christian conservatives get involved in politics, and they make, among many things, but they make abortion rights a very front and center in terms of their beliefs, that they want to overturn Roe. They think that that's an immoral and horrible decision. And so they get involved in the pro-life movement in order to make those changes. And that polarization continues today. While the majority of people support Roe and think that abortion should be available in certain circumstances, those on the extreme ends of the polls are the ones that are the noisiest, the loudest, and oftentimes get the most media coverage. And not just that, they get the most attention from political parties. And so, things really changed socially and politically, starting in the 1980s and continuing today, in part as a response to the decision in Roe. So the pro-life movement had specific goals they wanted to achieve in response to the decision in Roe v. Wade. One response was to amend the Constitution. There aren't a lot of things that can overturn or can trump, so to speak, the decisions of the Supreme Court. One thing, as we know, that can overturn a decision of the Supreme Court is another decision of the Supreme Court, right? And so you basically see that in this chapter, you'll see that the Bowers and the Lawrence decision having to do with sodomy laws and whether or not states have a right to criminalize sodomy. And in Bowers, they say, yep, the states can criminalize sodomy. If you engage in sodomy, oral or anal sex, that you could be charged with a criminal offense. That decision is overturned in Lawrence, right? And so that one way you can change a decision of the court is that you hope to get another decision of the court. Another way you can do that is by amending the Constitution of the United States, right? The only thing above the Supreme Court is the Constitution, right? So if the courts say that you have a constitutional right to abortion under the right to privacy doctrine, you could change that by changing the Constitution to prohibit abortion, or changing the Constitution to identify the right of a fetus, and that the fetus has the same rights as a fully out of the whatever womb human. Sorry, I can't come up with the language there. So you could amend the Constitution. It's incredibly difficult to amend the Constitution. And so while pro-life movements did say, let's try to have a right to life amendment added to the Constitution, their main goal was to overturn Roe. Okay, so get rid of Roe by having a new court say that you don't have a constitutional right to an abortion. And while they were waiting and putting cases forward, and you see that in the textbook, that the pro-life movement would put cases forward, hoping that this new court would, basically overturn Roe. In the meantime, an approach that the pro-life movement took was to change abortion laws and to make abortion laws more restrictive. And so while they said, hey, okay, you have a right to an abortion, that states began putting laws on the books, making it more difficult for women to get an abortion. Waiting periods, consent, we're going to take a look at those in a second. And that's really the question in the background of the Casey case, right? Because Casey is about the constitutionality of regulations that the state of Pennsylvania put into place. So let's take a look at those. Planned Parenthood versus Casey is a good example of a state that is trying to put regulations on abortion in order to, one, get a case having to do with abortion to the Supreme Court, not only to find out whether or not these regulations are constitutional, but whether or not, when presented with an abortion case, that it's possible that the Supreme Court could overturn Roe. And there were many states that were putting forth some of these additional restrictions on abortion to sort of challenge the courts to hear these cases so they could determine whether or not these laws were constitutional and whether or not women still had a constitutional right to an abortion. So the state of Pennsylvania amended its abortion laws, requiring women to seek, basically stating that women seeking an abortion must do these certain things. that they must, go to the abortion clinic and get informed about the procedure and sign a consent form. That they had to wait 24 hours after signing the consent form, waiting period, go home, I guess, think about your decision and come back. The doctors must provide a list of adoption agencies for women so that they could think about an alternative to abortion. If the person seeking an abortion was under the age of 18, they needed to have one parent provide parental consent, and that you had to demonstrate that the spouse of the pregnant person had been notified about the abortion prior to the abortion. And then also there were clinics had to keep extensive and comprehensive records of those seeking abortions, the age of the person seeking the abortion, the marital status, the weight of the fetus, etc. And so all of these were sort of like these regulations that were placed on abortion clinics and regulations that women seeking abortions had to deal with. Now, the thinking from the state of Pennsylvania was that, look, the state is well within its rights to regulate abortions, right? I mean, that even though in Roe it says that those regulations need to be related to maternal health, that, they're saying, no, the state has a legitimate interest in, making sure that people are considering adoption rather than abortion, that they're fully consented, that they go home and think about it. And so that was the position from from the state of Pennsylvania. Planned Parenthood said that these regulations are in violation of what was established in Roe, that women have a fundamental right to an abortion, and that regulations that are placed in abortion have to be related to a compelling interest of the state, and none of these rise to satisfying a compelling interest of the state. So let's look at the question before the court, and more importantly, the reasoning in the majority opinion. So the question before the court is, does the Pennsylvania Abortion Control Act violate the constitutional right to privacy, the right to have an abortion? And in a 5-4 decision, and it's, there's lots of concurring opinions along with the majority opinion written by Justice O'Connor, they ultimately judge in favor of Planned Parenthood, saying that in affirming the ruling in Roe, they uphold some of the regulations as being constitutional, and they strike down others. So let's dig in and look more deeply at the actual reasoning of the court in Casey. So in Casey, the central right to an abortion is affirmed. In other words, Roe v. Wade is not overturned. And that was really disappointing to the pro-life groups. They really were hoping that the court was going to throw out Roe, and they didn't. And so the central right is that states cannot prohibit women from choosing an abortion before viability. However, the court changed the standard used to accommodate the interests of the state. They throw out the trimester framework, right? And they're basically, remember, the trimester framework is saying you can have an abortion without regulations, with no interference of the state in the first trimester. And then as the pregnancy gets closer to full term, then the interests of the state become more compelling. And so that the state can put in regulations on abortion in the second and third trimester because the interests of the state are compelling. They throw that framework out in Casey. Strict scrutiny, they say, is no longer used to evaluate regulations. And so you have the right to get a pregnancy, but the court's saying that you don't, that regulations do not need to be related to a compelling interest of the state. Instead, they create this thing called the undue burden test. And basically they say that laws regulating abortions at any time in the point of the pregnancy, that the law is only invalid if it places a substantial obstacle in the path of a woman seeking abortion before viability. If the law doesn't present a substantial obstacle, if it's not unduly burdensome, then it's constitutional. If the law is regulation is unduly burdensome, presents a substantial obstacle, then that regulation is going to be deemed as unconstitutional. The court continues and says that states may take measures to ensure choice is informed. They can also persuade women to choose life as long as the measure does not pose an undue burden. So again, the regulations don't have to do with anything having to do with maternal health. They can just be that the state has an interest in encouraging women to become mothers, to keep with the pregnancy, to choose life. And as long as those efforts don't pose the substantial obstacle to getting an abortion, then they are constitutional. And then after viability, the state can regulate and forbid abortion except when the life and health of a woman is at stake. And so they keep that provision from Roe. So which provisions in the Pennsylvania law were deemed constitutional? Well, most of them were. Having 24-hour waiting periods were seen as well within the interests of the state. So those were constitutional. Getting a signed informed consent form was constitutional. Parental consent for a minor under 18 seeking an abortion was constitutional, except that they had to add that there had to be a judicial workaround so that if you can't go to your parents, you could go and get that consent from a judge. Clinics must keep comprehensive records. That demand placed on abortion clinics was seen as constitutional. The only provision that was seen as presenting a substantial obstacle on a woman seeking an abortion was spousal notification. Basically saying that if a woman is pregnant and they have to go to their spouse, the spouse they might be fearful that the spouse would be angry. It could be an abusive relationship, whatever. And basically saying that you have to put your life in danger in order to get spousal notification, in order to get an abortion, that was viewed as a substantial burden and therefore was struck down in the law. That felt that it does pose a substantial burden. So your textbook poses the question, like, what are we to make of Casey? Well, it doesn't overrule Roe. It reaffirms the central holding that a woman should have some freedom to terminate a pregnancy. However, it substantially changes the court's approach to evaluating the constitutionality of restriction and opens the door for states to put on even more restrictions on abortion. The compelling interest analysis is dead, as I stated in the previous slide. And now states can enact regulatory laws at any point in the pregnancy in an effort to promote life and motherhood, as long as it does not place a substantial obstacle to the right to get an abortion. So it's really a different ballgame coming out of Roe. And that's reflected in laws throughout the United States, and it's reflected in the kinds of cases that have been heard by the Roberts Court. So following Casey, states institute more regulations. And a lot of legal analysts who are looking at what's going to happen with Roe, a lot of those analysts say, look, Roe is probably never going to be overturned. But what's going to happen is that states are going to make it more and more burdensome for women to be able to exercise their constitutional right of an abortion, that it becomes like a constitutional right in name only, right? So there's this thinking for those, looking at sort of abortion jurisprudence, that Roe is not going to be overturned. It won't need to be overturned because Roe will just be chipped away at. So there's so many regulations on abortion clinics and making it more and more difficult for women to procure an abortion, that it's very difficult to exercise that right. Now, keep in mind that this is going to have implications for, income gaps, right? So in the case that we're going to be taking a look at here in a moment, that this is a case from Texas, and many of the abortion clinics, because of a law that was put in place, we'll take a look at in a second, closed, right? And so women would have to drive many miles. Texas is a big ass state, right? In order to get an abortion. Well, for a person who has a little wealth and time and can take off time from their job to get an abortion, right? That's not going to be as burdensome, right? Because they've got the money, they can pay for the hotel room, they can, have the vehicle, they can even fly to another state if they wanted to, right? But for people of lower income, women of lower income, right, that don't have a job that gives you time off, that doesn't, where they don't have the transportation or the means to stay in a hotel for 72 hours while they're waiting to get their abortion, it kind of creates a right, but a right that only people with economic means can actually access. So it'll be interesting to see what the future of Roe holds, and we'll be talking about that in a moment. So following Casey, states instituted more regulations. You might be familiar with these if you follow the news. It has to do with this case that was heard by the Supreme Court called Whole Women's Health in 2016. And this case had to do with these regulations called targeted trap laws, targeted regulations of abortion providers. And so again, in this effort to sort of put more make it more difficult for not just women to get an abortion, but for abortion clinics to stay open, Texas instituted two trap laws. One was, it said that any doctor working at an abortion clinic had to have admitting privileges at a local hospital like 30 miles away within like driving distance. And that was very difficult to do. And so a lot of doctors couldn't get those admitting privileges, and so the clinics would close. They also said that the abortion clinics had to make substantial changes to make sure that they had like met surgical center requirements, etc. You can read more about it in your textbook. Now keep in mind, abortion prior to viability is not any more dangerous than many other medical procedures that people have in an outpatient clinic, and that those outpatient clinics don't have the same level of regulations. But after Casey, that that there's sort of the door is open in terms of viewing these kinds of regulations as constitutional, and they would be given the Casey decision. So the case Whole Women's Health v. Hellerstedt comes to the Supreme Court in 2016. It's you'll note the date. It's after Scalia dies, and so it's a 5-3 decision because Scalia had not been replaced yet. And it was, so the question before the court was whether these trap laws were unconstitutional, and sort of surprising to many people that, the Supreme Court found that they were in fact, unconstitutional in a 5-3 decision. They basically said that the admitting privileges and the other Texas regulations are unconstitutional. And Breyers wrote the majority opinion in this case. He basically said he instituted what was known as sort of a cost-benefit analysis. He basically said that we're just not going to say about whether or not these regulations present a undue burden to the person seeking the abortion. But they said, look, what are the health benefits of these regulations? And do the benefits of these restrictions justify the burden that it's imposed on women? And if the health benefit outweighs the burden, then they're constitutional. But if the health benefit is non-existent or minor, and it really does burden women, then they basically do a cost-benefit analysis. And if the health benefits are greater than the burdens, then the law is constitutional. If the burdens are greater than the health benefits, then the law is deemed unconstitutional. And in Whole Women's Health, the court said that these regulations, the health benefits didn't even come close to justifying the burdens that were placed on women. And it's a pretty interesting decision given the makeup of the five, which we'll take a look at in a second. Okay, so this is a cool slide that graph that's from your textbook, and it's already outdated, even though it's the most up-to-date edition. And so it shows you like the court in dark black are the justices that affirm the central holding in Roe. Okay, and then you have Whole Women's Health, and then you see the court there. And on the last slide, I was like, see, look at the makeup. The five were Breyer, Sotomayor, Kagan, Kennedy, and Ginsburg. Okay. Those who were in the three were Roberts, Thomas, and Alito. And Scalia's seat had not been filled yet. Okay. So, you've got a robust five, right, that are supporting the central holding in Roe. Where are we at today? Very, very different. Breyer, Sotomayor, Kagan are still on the court. Okay. And so they affirm the central ruling in Roe. However, Kennedy has been replaced with Kavanaugh, and Ginsburg has been replaced by with Amy Coney Barrett. And so it looks like there might be a 6-3 bend towards overturning Roe. Now, as we know from judicial hearings, you can't ask questions of Kavanaugh or Coney Barrett about what their stand on abortion is. You can ask the questions; those questions were answered, but the justices refused to answer those questions, right? So we don't really know how Kavanaugh and Coney Barrett would rule on a Roe case. I will probably find out. But I would bet my bottom dollar that Amy Coney Barrett is likely to overturn Roe, given her, following in the footsteps of Scalia. She's kind of an originalist and has problems with the substantive due process doctrine. Not sure about Kavanaugh, right? So we'll see what the future holds. All right. Thank you so much for your time and listening. I thought it was really important to spend time on Roe and post-Roe with Casey, because your discussion this week is a hypothetical case where you get to act as a swing justice for a law that was actually passed by South Dakota that basically criminalizes abortion. Okay. So hopefully this will give you the background necessary in order to do well on that discussion, which I know y'all will. All right. Bye-bye. Go Crew.